Hi, everyone. I'm Emily Marsh, Events and Marketing Manager at the Greater Concord Chamber of Commerce. Thanks so much for joining our webinar this morning with Orr and Reno. This is the last event in this season's Orr and Reno webinars. They have put together so many presentations for us in the past year. I was trying to think of the number and I don't even know, but they've been crucial in helping us get out really key information to our members and the public this past year. So thank you, Orr and Reno, for sponsoring this series and providing these great presentations. Before we begin, I just want to, I've got this slide on screen to let you know about some upcoming webinars. I'll touch base about that at the very end of today's session, but wanted to let you know we are recording this presentation and we'll be sending it out to people afterwards, so keep your eye out for that. But since you are here live right now, you can submit questions during the presentation that Jeremy will answer here today. So to do that, you're going to either move your mouse a little bit or tap on your screen. You'll see this button called Q&A pop up. And from there, you can just type in your question and we will see it and we'll hopefully get to it during today's presentation. Please ask questions throughout. You can submit them anytime and we'll fit them in. So without further ado, thank you, Jeremy, for being here today, and I'll let you take it away.
Thanks, Emily. Everybody, thank you for joining us today. I'm actually based in Hanover in the Upper Valley, and as I look out my window right now, it's pouring rain and about 38 degrees, but I hear that Concord is pleasant and possibly even sunny, so I hope you're having a nice spring day. It's still winter up here in the Upper Valley, at least today. So I'm here today to talk about corporate succession in sort of the emergency context. And the reason that I stumbled on this particular subject for a presentation was that we were approached by a client about a month and a half ago, 2 months ago, who said, geez, my brother is, runs a company and he fell and hit his head and and basically has a temporary injury and he can't run his company. And he's got employees and he's got creditors and he's got contractors and he's got a business operation to run on a daily basis. And the company itself was a company that had to send trucks out delivery. It was an active, high intensity kind of business. And with the hospitalization of the principal member, the guy who was actually doing anything for this business, everything was at risk. And so this would be a corporation, a C Corp. So it was that was run by shareholders and a board of directors and a slate of officers as opposed to an LLC. But we had to look into what kind of mechanism we could implement in order to make sure that somebody could step in and take the reins of this corporation and ensure that it got its business done. In this case, it was the brother of the person who was injured who approached us, and we were able to help him out. But in some cases, it might be another member of the corporation, a partner. It might be a passive partner in the corporation, passive shareholder, or a passive LLC member that in normal times doesn't take any role in the management of the business, but when confronted with an incapacity on the part of the principal, the active member or manager, action must be taken. And so when we were looking at different options for how to help this person, it appeared to us to be useful information for any business or LLC or corporation to have for future planning in the event of incapacity or emergency. So I'm happy to take questions at any time. I think Emily has explained that if you do have a question, just hit the Q&A tab at the bottom of your screen, and go ahead and fire away, and I'll try to answer my presentation. I'm going to start with, sorry, share my screen here. So can everyone see that? Emily, are you able to see that?
Yep, looks good.
Thanks. So when ensuring corporate succession, first I'm going to cover business corporations, and then I'm going to cover LLCs and the kinds of tools available in the law for those kinds of entities. I'll touch briefly on DBAs or individuals. Turning first to corporations, the big tool that we used in the case that I just mentioned, and that exists under the statutory framework for business corporations, are the emergency powers provisions of RSA 293A. So the sort of plenary one is RSA 293A 303, emergency powers, and it expressly permits the modification of the line of successors, officers, directors, and so forth in an emergency. And it defines an emergency as any time that the directors cannot readily be assembled because of some catastrophic event. It doesn't define what a catastrophic event is. So as a corporation, any directors who aren't affected by the event can get together and enact a resolution whereby they invoke their emergency powers under this provision, simply with the declaration that a catastrophic event has occurred. And usually that's, we contemplate that, war, acts of God, fire, flood, and so forth. But in this case, the catastrophe was that the principal president of this corporation, the guy who did the day-to-day business, wasn't available because of his brain injury, and he was in the hospital. So the other shareholders got together and passed a resolution with him being absent, permitting permitting the appointment of an alternative president during the in question. And we drafted the emergency resolution such that it had a termination period by right, so a 180-day termination subject to renewability depending on the condition of the original president and his medical situation. And sort of putting those kinds of limitations on it are just in terms of defending a challenge to the propriety of the action. But in any event, what happens inside a corporation is really the business of the people involved. So very few people will use an action like this from outside. Where you sometimes get pushback is with creditors, or in particular banks, which might be looking for some kind of written authorization or power of attorney. I'll cover those in a minute. But in this case, a written corporate resolution enacted by the remaining directors or the shareholders of the corporation should suffice any bank to have authority that it can rely on to accept the newly appointed president as an officer of the corporation acting with the authority of the corporation. The other provision under the state statutory framework for corporations is RSA 293A 2.07, emergency bylaws, and it's a similar kind of framework. So in the event of some catastrophic event, directors can amend the bylaws of the corporation to address the emergency. So there are limitations inherent in that. If down the line some shareholders or some directors take opposition to the fact that these bylaws have been changed to address the emergency, they can certainly take action in court or otherwise to try and rectify the change in the bylaws. But the whole point of these provisions is to allow corporations the maximum freedom to act in a situation where they have an emergency. So these bylaws can be changed in any way necessary to perpetuate the management of the corporation during the emergency. And that's an incredibly broad power on the part of the directors to change the way the corporation works in case of emergency. And obviously, if it's a real emergency, in all likelihood, most people won't be challenging um, uh, the enactment. Um, if for reason those provisions aren't available, I mean, they're always available, but if people feel more comfortable going to court, you can always go to court to um, have a receiver appointed for a C corp. Uh, with a court is it provides the people who are going to seek this authority with cover, so to speak. So they are vetting their request with a third party, the court, putting in their evidence as to why they need the receiver appointed, and then it sheds liability to the extent that there might later be an opposition or an objection or some kind of challenge to that transfer of authority by a third party or a second party, that is another director or shareholder of the corporation. By having gone, the acting directors and shareholders can at least say that they made an equitable case to the courts and had the transition of power vetted by the court system before they enacted it. The courts will only grant a receivership under RSA 293A748 when it has been established that the directors are deadlocked in the management of corporate affairs, the shareholders are unable to break the deadlock, irreparable injury to the corporation is threatened or being suffered. And that's a pretty high bar to meet. But what it really does is it places the management of the corporation democratically in interested members, that is, of the corporation and their. So it's only as a last resort, after exercising all of the democratic means by which a corporation normally would act, that you would court to obtain a receiver. And a receiver is sort of like a guardian for a corporation. So the receiver acts in a fiduciary capacity to preserve the wealth and business and the assets of the corporation during a period of urgency of some kind. And the statutory framework and the general concept of corporations is set up such that the preference is that these issues are resolved internally by the corporate directors and shares prior to seeking court approval for a change like this. And before I turn to LLCs, some proactive measures that you can take in order to make it easier to exercise those powers democratically would be to ensure that in your corporate bylaws and in your articles of incorporation, if necessary, you provide for a line of succession in case of emergency or in case of the incapacity of a director or officer. And a specific sequence of authorities that are set out and agreed upon by the shareholders of the corporation in advance before the emergency happens. That provides incredible flexibility to the shareholders and to the directors. Hence, there's any kind of mechanism that you can set up, whether it's relying on a designated agent or appointed counsel or a completely off the wall mechanism, as long as everybody agrees to it, then it's a valid way of ensuring corporate succession in advance. With respect to LLCs, LLCs are governed under a slightly different corporate structure. They're considered to be partnerships by the IRS, and so they're governed by New Hampshire's partnership structure statutorily. RSA 305 specific statute governing LLCs. When you have a multi-member LLC, if there's no manager, then if one member who typically acts on behalf of the corporation is incapacitated fashion, any of the other members reigns. So there doesn't have to be any transfer of authority if you've got a multi-member LLC and there's no manager. If the LLC members have elected to appoint a manager to run their affairs, if that manager becomes incapacitated fashion, the members can elect a new manager, whether that's a outside manager, which is permitted, or one of the members can be appointed a manager. In any event, it is again that internal democratic, as you have members able to vote, take action to secure the continuity of the LLC during the period of incapacity of that acting member. You only need a majority of members who can vote for a new or temporary manager. And in the event of a death, you can get a court to appoint a receiver for the purposes of advancing that particular issue. And a receiver doesn't have to be a third party. The receiver could be one of the members of the court that they're in the best position manage the affairs of the LLC during the period in which the transition is necessary. With respect to a single member LLC or a DBA, it's a slight analysis, because if you a single member LLC and that person goes down in some fashion, then there's nobody left to run this business. And you might see this in with a small business run by an individual, maybe a contractor, operates his LLC by himself and is the principal actor. And maybe the only other person with any knowledge of his business might be his spouse. And so in that case, what that person should do in advance is figure out and think about corporate success issues in the event of some kind of incapacity, so that the question is answered before the occasion arises. As always, that's the best remedy. In the event that can't happen and the element doesn't address that issue, the courts can appoint a guardian over that individual, and that guardianship can be comprehensive. In other words, guardian can take over all of that person's affairs, or it can be limited in scope to just the business affairs for that individual. So let's imagine that there's a spouse who runs a computer shop in a local mall, and she falls ill through a car accident and she can't come to work more. So her husband goes to court and says, I'm not a member of the LLC, so I can't act on behalf of the LLC. The banks won't accept my representation that I'm her agent, so I need a guardianship. Well, do you need a guardianship over her whole, i.e. her personal issues and affairs? And he might say, no, all I need is a guardianship that allows me to act on behalf of her LLC. And armed with that order from the court, take the reins of the LLC as guardian. So she would still be the primary member and manager of her single member LLC. It's just that her power to act would have been supplanted by his power under the court order. And again, to a receivership, um, to a guardianship over an individual would be a receivership allowing him or her to act on behalf of the single member LLC. And these are court processes. These are helpful in through a lot of red tape, so to speak. You can invoke the general powers of the court to get something done, and the court can exercise those powers in a comprehensive and tailored relief necessary need done. Courts have enormous power in that regard. However, in order to invoke that power, you need to file a lawsuit. You need to hire an attorney, usually, unless you're familiar with court's work. And that requires this and service fees and costs related to serving the action on the necessary parties, and then engaging in what can sometimes be a lengthy court process, because courts never act in a timely fashion, at least from my perspective. It always takes a long time in court. And so that's the disadvantage of using a court for these kinds of transitional situations. So again, the best solution would be to think about this stuff in advance and try to come up with your alternatives before they're necessary. Receiverships generally are part of the court's common law powers. That means that they are intrinsic to the inherent of the court. They're referenced places in RSA 491(7)A, which is a subsection of our statutory framework that sets up our business court in New Hampshire, and it designates all actions related to the internal affairs of government, business insolvencies, and receiverships to the court, which sits in Concord. But it's a general power of any superior court. And like I was saying, it's an immense power that can be tailored to any circumstance, and it serves like a guardianship for the alternatives are a bylaw and LLC agreement provisions which address emergencies. You could sit down and craft this together as a group. You could sit down with your legal counsel and different arrangements that you would incorporate and put into those LLC agreements and bylaws. It permits substantial creativity. You could have multiple sets of triggering conditions that allow things to take place, ensuring corporate success. And then another option for single member LLCs, or like a small LLC with active and passive members, you could have a POA set up. So the LLC would create a power of attorney designating some individual to become the manager in the event of a certain set of circumstances. An example of a kind of situation you might see, again, might be a small family-oriented LLC. You have elderly parents, passive members of this LLC, and their son runs the business, does all the work, and they just get a distribution at the end of the year for having, say, invested in helping him acquire capital. Might set up a POA that designates a friend who he trusts to be the manager in the event that he loses capacity. So that POA could be set up and held in escrow, in trust, by a lawyer. One of the other members could approach that lawyer and say, hey, my single member who's most active has fallen ill. Can we invoke that power of attorney now? And then break in case of glass provision is invoked, the attorney verifies that the member is down and out and unable to, on behalf of the LLC, and using that attorney's best judgment combined with that attorney's fiduciary to the corporation, he would then present the POA to the person designated in advance to assume the reign or LLC in a time of like that. This is a pretty common provision that you see in ordinary durable power of attorney situations. So an elderly person might create a power of attorney in their son, but not want to turn it over. Themselves are without capacity, and so they give it to their lawyer, who they trust, and they trust to be an independent third-party analyst. And they say, "Look, I want my son to act on my behalf, but I don't want him to act or have the power. I'm really unable to act." And so that judgment, if you make the call that I am incapacitated in your best judgment, then you can go ahead and turn that over to my son. And that places some burden on the attorney to figure this out. The attorney can seek instruction from a probation under those circumstances, but usually it's, in the case that I was discussing earlier, the individual who was most active in this corporation was unconscious in a hospital for more than a month. So somebody had to act, and it was clear that without the corporation could fall into difficulty. So those are the different mechanisms that exist to ensure corporate succession. And I think the general rule would be try and work it out in advance, make sure you have something in writing, and try and foresee those eventualities. And in most instances, if they don't, there's a nice statutory backup on the corporate side. And generally speaking, LLCs are pretty flexible to begin with. And so they provide a nice framework for annuity in the event of the incapacity of one member. So I'm going to close this PowerPoint and see if we have any questions yet. And I see that we don't as of this time. Has anyone out there had a situation where they needed this kind of corporate succession?
It's a good question. So for those of you watching right now, if you'd like to submit something, comment anything, you'll want to click on Q&A and type in right there, and we'll be able to see your comments and questions. Um, I was wondering, Jeremy, if you might be able to expand a little bit upon how this might relate to the current pandemic, particularly as far as like what if a major outbreak were to happen, where you have maybe your like main manager is directly in contact with a board of directors or something, so that they all would become ill or incapacitated. What would happen
Yeah,
then?
I mean, if everybody and was incapacitated, left over could take advantage of these provisions to try and manage the affairs of the corporation. And even if everybody wasn't sick, but everybody was dispersed for some reason, so perhaps you have a corporation that requires a meeting, um, typically allow some flexibility in that regard. Sometimes directors can't get together for a meeting for whatever reason. The remaining shareholders and directors under our statutory framework for corporations can call a special meeting in order to take action on behalf of the corporation. And they can do it with a quorum of the directors who are, and that, again, that is to act when not all directors can be present and making decisions.
And then I don't know if you can talk a little bit about what you mentioned it at the beginning. What is an emergency?
Oh, good question. This is a great,
What is incapacitated?
yeah, no, these are great terms to debate, but they're uh, not defined under the terms of the statute. So that gives the corporation and the people trying to solve the problem under the circumstances a wide degree of latitude in defining. So if a corporation says, hey, we've got an emergency that's preventing all aggregating and coming to, then they can invoke those emergency powers. And in the case that I mentioned, the emergency wasn't some earthquake that prevented people from driving from Concord to Manchester. It was that one of the directors, the main director and officer, was in the hospital. Big emergency because the board as a whole, if one of the two directors was incapacitated. So it met the terms of the statute. Um, and the corporation's actors, the people in the corporation, whether that's shareholders, directors, or officers, can take that action in reliance on those provisions and not worry that they're acting outside their authority. That doesn't mean it can never be challenged, of course, but a basic um, protection in that the law that authority, and if nobody's challenging them when they make the decision to do that, then it's presumptively valid. And I see a question. When the business owner recovers and is ready to return, powers end. And I think what I did in this particular case was we drafted the corporate resolution to terminate of its own accord at 180 days. A lot of people, at the business owner who has been appointed, or the person who has been appointed to operate the affairs of the business while the principal actor is incapacitated, a lot of the people that interact with that individual on a daily basis won't care about waiving that piece of, getting authority from that person to say, hey, are you acting on behalf of the corporation or not? If you're a contractor who just wants this business to do what it's supposed to do, you're not going to challenge the authority of a guy who comes up to you and says, hey, what do you need me to do today for the corporation? You're just going to get the job done. That's how the real world of business works. But if you have a more sophisticated interlocutor like a bank or a creditor, a major creditor of some kind, or some kind of government agency that wants to take action on behalf of this corporation, then they might. And if the corporation's resolution terminates of its own accord after 180 days, then it gives kind of a stop gap so that the director who's out for the time being, he can always reassert and say, look, 180 days has passed, I'm back in charge again, and I'm now running the corporation. In the event that that person comes back before the corporate resolution terminates, or if it's an indefinite corporate resolution appointing a new officer, then that person would come back as a director of the corporation and seek to amend that resolution just as he would any corporate decision. So they would step back into the chair, reassuming their full capacity as acting individuals in the world, and say, look, I want to now withdraw that resolution because I can now act on behalf of the corporation again. That person gets outvoted by a majority remaining shareholders or directors, then that's a corporate decision. But usually you don't encounter that.
Sorry, my computer's being a little slow to get me back online.
Yeah.
That's all that I see for questions right now. We'll keep this open. If it's okay with you, Jeremy, I'm going to switch and do some announcements. And hey, we always love wrapping things up early. It means, you covered everything that people need to know, Jeremy. So I'm going to share my screen real quick. Uh, okay, I just want to let you all know about some upcoming things for the chamber. Tomorrow, we have another webinar. This one is covering HR priorities, to think about in 2021, and it's sponsored by HR ROI Consulting. We have a deadline coming up for our Pinnacle Awards ceremony. So we are going to be giving awards to Small Business of the Year, Nonprofit of the Year, and Business Leader of the Year. Nomination deadline is this Friday, so you might want to sneak those in if you haven't submitted yet. We just made a really big announcement that this event will be in person, outdoors in June. We haven't finalized everything yet because we're waiting to see, what will be safe, what will be possible. But we are planning on something outdoors and socially distant. So we're excited about that. And then a week from today, next week, we have another webinar presentation about social responsibility programs that your business may be engaging in or may be looking to engage in order to, um, there's a lot of benefits that come with that. So that is what that webinar will cover. You can sign up for any of these online at concordnhchamber.com. I want to thank you again, Jeremy. This is a really timely presentation. I know we're going to have people checking out this video for a while. So thank you for being here, and thank you for everyone who could attend right now. We
The
appreciate
only
it.
thing I would say is if anybody has a follow-up question, please just email me. I'm happy to answer. I want fees for that. But if anybody has questions, provide informal feedback on stuff like that, as long as it's not related to a specific question
Yeah.
or, specific set of circumstances. But if someone has a follow-up question or they're curious about something, my emails are open and you can, that's it, folks.
Well, that's great. Our members really appreciate that. Orr Reno is so open about, just letting people ask more questions and follow up after these presentations. So really, truly, if you have questions, go ahead and ask. We'd be happy to connect you. So thank you again, Jeremy, and thank you to Orr Reno. Anything, final on this presentation you'd like to add, or, anything I may have missed here?
I don't think so. I hope nobody needs any of these emergency powers and everything goes smoothly and everyone makes a lot of money.
That is, yeah, I think we can all agree on that. All right. Well, thank you. And have a great rest of your day, everyone, whether it's sunny or snowy where you are.
See
All
ya.
right. Bye.